Good afternoon. My name is Donna Fiesel, and I'm your host of The Edge on IC Radio, your source for news and entertainment. You can also find us on television, channel 182 on Charter Communications, and we are syndicated on Abundance TV, found on Roku, Apple TV, and Amazon Fire. Thank you again so much for watching all the stuff happening, President Trump and the indictment. What in the world is going to happen? We don't know, but I'm pretty sure it's going to be pretty interesting. One thing I do know, and this is from being a Christian and being a conservative, is the truth will come out. Whether it's something we like or we don't like, the truth will come out. And anybody who may be trying something to hang someone, sometimes that happens, they will be found out. I do know that for sure. So anyway, let's just breathe, relax, and just take in the scenery. Okay, what's going to happen is going to happen. Plenty to talk about. Don't get too upset with people if they say something you don't like. Just relax and breathe. Okay, so we're going to talk a little bit more in detail about a brief description of the federal criminal justice process. This is found on FBI.gov. FBI.gov. Okay, a brief description of the federal criminal justice process. What's it all about? Some victims are unfamiliar with the operation of the federal criminal justice system. For others, their knowledge is limited to what they've seen on television or in the movies, which oftentimes is wrong. To help federal crime victims better understand how the federal criminal justice system works, this page briefly describes the common steps taken in the investigation and prosecution of a federal crime. Not every step described will occur in every case. In some cases, the investigation or trial may involve additional events or proceedings, all of which could take a long time to complete. So, an FBI victim specialist or the victim witness coordinator at the U.S. Attorney's Office can explain the specific process in a particular case. Now, number one, the pretrial stage. Okay, let's talk about this. Investigations, grand juries, and arrest. Now, if a crime is brought to the attention of federal authorities, whether by a victim or of the crime or a witness to it, like let's say like a bank robbery or something like that, a federal law enforcement agency will undertake an investigation to determine whether a federal offense was committed, and if so, who committed it. 2 points should be kept in mind. First, not every crime is a federal offense. For example, murder is a crime in all 50 states, but it is not a federal offense unless, for example, a federal official is murdered while performing official functions. Now, robbery is also outlawed in every state, but it is not a federal offense unless there is some connection with the federal government, such as the robbery of a federally insured bank. Federal law enforcement agencies will investigate a crime only if there's a reason to believe that the crime violated federal law. Now, second, the nature of the federal offense may determine which agency undertakes the investigation. Not every federal law enforcement agency has the ability to investigate every crime. For example, the Secret Service is responsible for investigating counterfeiting of currency, and the FBI is the lead federal agency for terrorism cases. This assignment of functions helps different agencies develop expertise, but it also means that federal law enforcement agencies are not like the local police forces. They do not handle whatever federal crime comes their way. If the agency concludes that a crime was committed and identifies a suspect, federal law enforcement officers known as special agents may also make an arrest without obtaining an arrest warrant. May obtain an arrest warrant for a named person, or in some circumstances may delay making an arrest in order to obtain additional evidence proving the suspect's guilt. In the case of federal offenses that are known as white-collar crimes, like violations of the federal securities laws, agents often will need to obtain documents from suspects and innocent parties as part of the investigation. To do so, the agents can apply for a search warrant from a magistrate or a judge to search a particular site for relevant evidence. Alternatively, the agents can request a subpoena from a grand jury. Now let's talk about the grand jury. The grand jury is an impartial body of citizens, we hope, drawn from the community that has been responsible to investigate whether a crime has been committed and by whom. In order to make that determination, a grand jury may issue subpoenas to whoever they may have evidence relevant to the grand jury's investigation. Now, as part of its investigation, the grand jury also has power to compel testimony, including the testimony of a crime victim. Now, if the grand jury concludes there is probable cause to believe that a particular individual committed a crime, the grand jury will issue a charging document known as an indictment. Whenever a grand jury is involved in an investigation, the agents will work closely with an attorney from the United States government, whether from the local U.S. Attorney's Office or the U.S. Department of Justice, before making an arrest in order to determine whether a crime was committed and, if so, who is responsible. Initial appearance. If a magistrate has issued a search warrant for a suspect, or if a grand jury has returned an indictment against a suspect, federal agents will arrest the suspect and place him or her in custody pending the court proceedings. If there has been no arrest warrant or indictment, the arresting agents must bring the suspect before a magistrate or a judge, who will then determine whether there is a probable cause to believe that this person actually committed a crime. Now, the initial appearance generally will occur as soon as practicable following arrest and must occur before 72 hours have passed. At the initial appearance, the court will inform the arrestee of the charges and advise him or her of the rights to counsel and to remain silent. In some cases, the defendant may be released at the initial appearance. In other cases, the prosecutor may seek to have the accused held in custody until the trial has concluded, because the accused is seen as a danger to the community. Okay, let's talk about this, the oversee of the criminal process. Okay, first you got the crime, and then enter into the system the interviews, the investigations, the arrests, and the complaints. Next, the prosecution and pretrial services, the charges filed, appearances, preliminary hearings, bail or defendant hearing, grand jury, then indictments. Now, the adjudication process. Okay, arraignment, trial, guilty plea, conviction, sentencings and sanctions. That would be sentencing and then sanction, and then corrections, probation, or prison. Okay, now the arraignment. The arraignment is the stage at which the defendant formally is told what the charges are and is given a copy of them. The defendant then enters a plea responding to those charges, which generally is not guilty or guilty. If the defendant and his attorney already have negotiated with the prosecutor and have agreed upon a plea bargain, the defendant may enter a guilty plea at the arraignment as part of the plea bargain. Now, plea bargaining is discussed below. We're going to talk about that in just a few seconds. I wanted to remind you, this is website fbi.gov, fbi.gov. Now, discovery and motion practice. After arraignment and before trial, the defendant and the government engage in the discovery and motions process. Discovery is the pretrial process by which the defendant and, to a more limited extent, the prosecutor can demand information and material about the case from the other party. In addition, the defense and prosecution usually engages in considerable pretrial motion practice. This is a motion, and the name is given to papers filed with the district court asking to do something in the case. For example, motions filed by the defense may seek to dismiss these charges, to suppress evidence, or to introduce specific evidence at trial. Motions by the prosecutor may include a request to the receptacle disclosure or a request for defendant to disclose alibi or psychiatric evidence. Now, a crime victim's attorney may also file motions asserting the victim's rights. For example, a victim's attorney may seek to squash a subpoena issued to a victim to prevent the victim's personality identifying information, that's called the PII, from being made public, or allow the victim to remain in the courtroom during the trial. Let's talk about plea bargaining. The government and the defendant may agree to forego a trial and have a defendant enter a plea of guilty as part of the plea bargain. Now, plea bargain is an agreement that the defendant will plead guilty to the original or other charge in return for some concession from the prosecutor. Typical concessions include dismissal of other charges or a recommendation to the judge for a particular sentence, or an agreement not to oppose the defendant's request in a particular sentence. If charges have been filed, a victim will have a responsible opportunity to confer with the prosecutor before the plea bargain results in a formal guilty plea. Nonetheless, a victim must not have the right to veto the prosecutor's decision to engage in plea negotiations or to accept a guilty plea from a defendant as part of a plea bargain. Now, if a plea bargain agreement has been reached, the government and defense counsel present that agreement to the court. A victim may appear in court and make a statement regarding the plea agreement. If the court accepts the agreement, the court will set a date for sentencing and decide whether the defendant should be held in custody until then. The law does not require a federal court to accept a plea agreement. Rather, the court may accept the agreement, reject it, or discuss with the parties alternatives that are acceptable to the court. If the court rejects the plea agreement, the defendant may withdraw the guilty plea and the case will proceed to trial. Okay, let's go ahead and do another one, and then we're going to go into a commercial break. Now, number 2, the trial. A trial is a proceeding during which the government and the defense present evidence to prove or disprove the charges. Now, ordinarily, a trial is held before a jury, but there are circumstances in which the case will be tried to the judge alone, which is known as a bench trial. The purpose of the trial is to decide whether the government can prove beyond a reasonable doubt the truth of the charges against the accused, but a victim is not a bystander in that process. For example, a victim may be called to testify as a witness to the crime or to explain how the victim was harmed by the crime. Moreover, except in extraordinary circumstances, a victim cannot be excluded from the trial, even if the victim later will testify, which enables a victim to observe the in-court proceedings. Generally, a trial proceeds as follows, and we're going to do that right in just a few minutes when we come back from the commercial break. You hang up. We'll be right there in just a minute. The Hatter Cafe and Country Inn is nestled in the northeast corner of Alabama the Beautiful in the delightful town of Mentone. We're located on top of scenic Lookout Mountain near Little River and DeSoto State Park and located only 5 minutes from shopping and restaurants. There is also a nearby community walking path and golf course. We welcome everyone through the doors and we are committed to outstanding service for all guests. At the Hatter Cafe and Country Inn, we invite people from all walks of life to come and get away from it all, enjoy the open spaces, treetop views, fresh, clean air, and experience Southern hospitality at its finest. We look forward to hosting you. To reserve a special event, or if you would love a special getaway at the Country Inn, you can call us at 256-634-2018. Jeff McCurdy of the McCurdy Law Firm has been a public service of this area for over 10 years. McCurdy, a member of the Henniger City Council, serves as prosecutor for the town of Sylvania and was named public defender for the city of Rainsville. The McCurdy Law Firm is located at 17326 Alabama Highway 75 in Henniger to better represent his Jackson and DeKalb County clients.
If you need to be represented by a true public servant with proven success, call Jeff at 256-996-8701 or send a private email to mccurdy.lawfirm@gmail.com. No representation is made that the legal services performed is greater than the legal services performed by other lawyers.
The only place I buy my beef is Lone Tree Ranch in Collinsville, Alabama. Their cattle is born and raised on their ranch, grass and grain fed, and you can feel confident when you serve your family and friends because their beef is all natural and no antibiotics or hormones are added. You can buy whole beef or perhaps go in with family or friends and buy half. Their customer service is number one as they take care of the delivery to their local processor and can deliver to your home for a small added fee. They also offer herd replacement heifers. I always call Lone Tree Ranch in Collinsville, Alabama for my beef specialty recipes and cookouts, and you can too. Food shortages are increasing, so buy local by calling 256-523-6462. That's 256-523-6462. Okay, we are back. My name is Donna Fiesel, and I'm your host of The Edge on IC Radio, your source for news and entertainment. You can also find us on television, channel 182 on Charter Communications, and Abundant Television, which is found on Roku, Apple TV, and Amazon Fire. We're talking about the trial. Generally, a trial proceeds as follows. Let's go ahead and finish this up. It's called the voir dire. This is the process for which members of the community selected to become potential jurors in a specific case are questioned and selected for a particular case. Now, in a capital case, this is split into two phases, the general phase and the death qualification phase. Now, the reason for the separate death qualification phase is that the government is entitled to excuse from jury anyone who will not consider imposing the death penalty when it's a potential punishment in a specific case. Now, the guilt stage: opening argument, presentation of evidence, closing arguments, jury instructions, and deliberations. Now, the guilt phase generally begins with the prosecutor's opening statement. The defense has the option of making its own opening statement immediately afterwards or reserving its opening statement for the beginning of its case in chief. Now, the prosecutor then presents the government's proof through physical evidence and witness. The defense is entitled to cross-examine any witnesses questioned by the government. Once the government has completed its case, the defense may move the court to acquit the defendant on the ground that there is legally insufficient evidence to convict. If the court denies the defense motion, the defense may present its own case, and the prosecutor may cross-examine any witnesses presented by the defense. Now, following the defense case, the prosecutor may present evidence to rebut the defendant's case. Once the prosecutor concludes its rebuttal case, the defense again can move for an acquittal. If the court denies that motion, the parties present their closing arguments. First the prosecutor, then the defense, and finally the prosecutor again. And in quotes, the government goes first and last because it was the burden of proof. That's what that means. Following closing arguments, the judge will instruct the jury on the relevant law for it to apply. Afterwards, the jury will retire to decide the case. Now, when the jury has reached its decision, the jury will return to the courtroom and announce its verdict. If there is no jury, the judge will deliberate and return a verdict. Okay, the sentencing stage. Let's talk about that. The pre-sentence investigation, the defendant's right of allocution, the victim impact statement and the parties' arguments, and the imposition of sentence. So let's talk about this for a few minutes. If the jury or judge finds the defendant guilty of at least one count charged in the indictment, the court will impose some sentence on the offender. But before the court does so, a probation officer will conduct a background investigation. The probation officer will investigate any aggravating or factors present in the case and will prepare a pre-sentence report summarizing those factors for the judge. So a lot of detail goes into here. Most reports contain a variety of information. It may be helpful to the court, such as information about the offender's prior criminal record, personal characteristics, financial condition, social history, and circumstances affecting his or her behavior, as well as information regarding the effect of the crime on the victim. Now, regarding that last subject, let's talk about this for just a few seconds. During the background investigation, a probation officer will speak with the victim. The officer will ask the victim to complete a form and to provide whatever documents the victim may have showing losses or expenses caused by the crime, such as medical bills, lost income, that kind of thing. Now, the victim will also have an opportunity to prepare what is called a victim impact statement. It's a statement describing, in the victim's own words, the effect of the crime on the victim. That statement will be presented to the judge and made a part of the record at sentencing. Now, the offender has the right to be present for sentencings, and so does the victim. Both persons may make a statement before the court imposes the sentence. The lawyer for the government and the offender will also address the court regarding the sentence. If a victim is represented by an attorney, the victim's counsel can also address the court at sentencing. After hearing from those parties and the government, the court may sentence the offender to imprisonment, probation, community service, or another such program. If an offender is imprisoned, the offender will be placed on a period of post-release supervision. Now, the court can also fine the offender and order the offender to pay restitution to the victim. Restitution is a monetary payment made by an offender to the victim to compensate the victim for the financial harm caused by the crime. And the judge must order the offender to pay it. Now, a victim can urge the court at sentencing to enter an order requiring the offender to make restitution to the victim. Okay, so let's talk about the post-trial proceedings. After sentencing, the offender may appeal his conviction or sentence in the hope of having either one set aside. An offender has the right to appeal to a circuit court of appeals. If that court does not grant the offender the relief he seeks, or he or she can ask the U.S. Supreme Court to review the case. But the Supreme Court has the discretion whether to review an offender's case, and it reviews very few federal criminal cases each year. If the Supreme Court decides not to review the offender's case, or if it does but upholds his conviction and sentence, the judgment against the offender now is final. At that point, the offender has few opportunities to obtain relief. The offender can challenge his conviction or sentence in a habeas corpus proceeding, but there are only limited opportunities for the offender to obtain that relief. A victim can attend in-court proceedings involving the offender's challenge to his conviction or sentence. Now, another avenue of relief is to ask the president for clemency. That is to pardon his crime or reduce his sentence. But the president exercises his clemency power rarely. Kind of doubt that this current president would do that for Trump. A victim does not have the right to attend Justice Department meetings on a clemency application, let alone meet the president before he takes action on a clemency application. But a victim can write to the Justice Department about the matter. For most of the 20th century, an imprisoned offender could be released on parole before completing his sentence. Now, a paroled inmate was subject to supervision until he had completed his sentence. Congress repealed the federal parole laws more than 20 years ago, but offenders who committed crimes before November 1987 are still eligible for parole. A victim has the right to be notified of a hearing at which government officials would decide whether to parole an offender. Okay, now here's the next step. Indicted versus charged. What's the difference? I found this from the law offices of Jeffrey G. Nathan. Okay, if you've been indicted or charged, you may be wondering what the difference is. Okay, essentially the difference between the two depends upon who has filed the charges against you. If you have been charged, this means a state or federal prosecutor filed charges against you. If you've been indicted, this means a grand jury has filed charges against you. Okay, now this is what a criminal charge is. A criminal charge is an allegation of a formal nature from law enforcement that you've committed or more crimes. One or more crimes. This can be a misdemeanor or felony charges. After you are formally charged, you can be arrested on a warrant if you already were not placed under arrest. If you were placed under arrest before the warrant was issued, the state attorney's office will decide if you should be charged based upon the evidence before him in the charging affidavit provided by the police officer. Now, if you were arrested by warrant, the police are required to give you a copy of this document stating the charge that you have been arrested for. Okay, this must occur within a reasonable time after you've been placed under arrest. Note that criminal charges can be changed later by the state prosecutor or by the grand jury. Okay, after you are placed under arrest on a misdemeanor charge, the state prosecutor must charge you within 3 months of the arrest. If it's a felony, you must be charged within 175 days. Now, if charges are not filed within these time frames, the case will be dropped. Now, the arrest. After you've been charged, you will be arrested and should be advised of your right to remain silent. Also, you have the right to call an attorney and have one present during questioning, and to have public defender appointed if you cannot pay for an attorney. Okay, now bail, if the crime is relatively minor, you may be released without bail, which is on your own. If you're placed in jail and do not have the money for bail, the state prosecutor has 30 days from the date of arrest to file charges. If you're placed in jail and your charge is serious enough to require the payment of bond for release, that amount is set by a judge. If you hire a bail bondsman, you usually have to pay about 10% of the bondsman, but you need to have proof of collateral, such as a vehicle that you own free and clear. Then there's the arraignment, then there's the criminal indictment, and then question witnesses, and then you may testify, and then what to do next. Now, if you are facing a charge or indictment from the federal government or the state, you must obtain a strong criminal defense attorney like now. You mentioned this in the previous show. Whether you've been charged or indicted, you'll have the U.S. or state government pursuing a conviction, and you need a strong legal advocate to lead your side. Indictments especially are very serious, and you need an attorney who is very familiar with the indictment process for you if you have a chance to escape from the indictment process unscathed. So I'm going to go ahead and call it the end today. We're going to have a lot of questions. Lots and lots of very, very smart folks are going to be coming on the show very, very soon. And we're going to be talking about this indictment, President Trump, and what is happening. So I appreciate you watching. My name is Donna Feazell, and I'm your person right here on the edge where your thought for, let's get everything right. We're hearing all these things that are not correct. So let's just get this all right. Okay, you can find us on television, channel 182 on Charter Communications, and Abundant Television. We are syndicated to channel 182 and Abundant Television. You can find us on Roku, Apple TV, and Amazon Fire. Thank you so much for watching. I really do appreciate it. We'll see you next time.